Chair, Honorable President, Mohtaram Fakhar Imam Sahab, General Shoaib Sahab, General Sahab, Assalamu Alaikum, and honorable guests. What the BJP government is doing, I think it has been summarized very adequately by the Chairman Joint Chief, that the nuclear weapons are in the hands of a very irresponsible regime, an extremely irresponsible group of people who have no clarity in terms of creating a framework for a reasonable and a responsible use of the arsenal that they have at their disposal. So it's a concern, it should be a concern for the international community as to how to handle this regime and its irresponsible overtones, which not only are manifesting themselves on the action of 5th August, but also at the same time in respect of supporting, sponsoring the lynching culture which is taking roots in India. And this lynching culture and this culture of creating discrimination against the Muslims and the Christians is giving rise to a new wave of anger and anguish amongst young men in India, who are beginning to now also resort to violence. And if this anguish, which is because of the BJP government's actions, measures and sponsorship of irresponsible acts, is tied up with Kashmir and it gets linked up. Fakhar Imam Sahab, अगर काइंडली मैं थोड़ा सा ये अर्ज कर रहा हूँ कि जो एंग्विश यंग एंग्री मैन का है इंडिया के अंदर, अगर वो टाई अप हो जाता है विद कश्मीर के साथ और कश्मीर के हवाले से आवाज़ें पूरे हिंदुस्तान में गूंजना शुरू हो जाती हैं विद इन द मुस्लिम कम्युनिटी, and you also have support from the Sikh friends who also are responding not only within India but outside India to the call for self-determination, and that is something which is extremely meaningful. So you have a mix of a situation which is likely to endanger international peace and security in this region. To me, sir, that is a sufficient ground to plead before the UN Security Council that the urgency requires, the methodology of the BJP government requires that Security Council should take cognizance of the anger it is unleashing in this region, which is likely to turn to violence, and this violence will be of a racial nature, this violence will be a genocidal in nature, and it can come and join hands with the Kashmiris, and you will have an explosive situation based on which they will be called for jihad. There will be Indian diaspora and there will be Muslim diaspora and Pakistani diaspora and Kashmiri diaspora in Europe, in US and elsewhere, who would be going against each other. You saw an incidence of the fight of taxi drivers, Indian and Muslim Pakistani taxi drivers. There was a video in somewhere in the Middle East. Now you have a very unique situation in Europe, where Indians and Pakistanis and Kashmiris are living side by side. In case of a simple test cricket match, one-day match, you have tensions between the both communities. And here, the anger that I am sensing, the kind of emails I am getting from the diaspora of Pakistani origin and of Kashmiri origin, tells me, indicates to me, we are looking at a very explosive situation in those countries as well. So we need to bring home this point to the EU ambassadors, to the P5 countries, that this is not going to be limited to Kashmir. This is going to lit fires of disorder. This is going to lit fires of serious mismanagement anywhere in the world. So if they do not take cognizance of this crisis and try and find a framework for its resolution, we are staring at a very serious breakdown of global peace and security in more than one places. You would recall, and all of you would recall, in case of Palestine, you had an issue of Palestine somewhere in the Middle East, but the hijackings were done in Munich. Somebody was blowing himself at elsewhere. So you never know. The desperation can lead to desperate measures. So I personally think the kind of anger that I am seeing, which is coming out, the kind of questions that you are facing at various forums, whether local or international, the kind of telephone calls I am receiving from Europe, from America, I clearly sense if there is no organized framework to handle this crisis by the P5 initiative, we have a serious global issue at hand, which is something that Security Council needs to take notice. Let me remind you, ladies and gentlemen, P5 in 1998 issued a formal pledge, that they will make efforts jointly to help India and Pakistan to resolve these issues. This pledge is part of documentation. It was in the Security Council. So P5 could be reminded of that pledge. P5 could be reminded that you had given this undertaking in the United Nations in 1998 pursuant to 1172. There was a Secretary General's letter written, and then there was a P5 formal statement. In the preparatory work that I do, we have set up these set of legal documents on Kashmir. So as a lawyer, you are trained first to put your brief in order. So my team has put together a set of documents that in our view constitutes an essential reading before you can take any policy position or a political position or even a diplomatic position on Kashmir. They may be well equipped, but I'm talking in a general sense. Now these documents tell us that Pakistan has an outstanding case in the lawfare domain. And if you would remember, sir, in May this year, when you held that seminar, I said I'm feeling uneasy because on 27 February, Article 370 challenge was fixed before the Supreme Court of India, and my team was monitoring the cause list of the Supreme Court of India to understand where is this case going, because prior to that, we had detected in 2015 two judgments of Jammu and Kashmir High Court in which Article 370 was discussed. An attempt was made, some people, to have it dislodged judicially. The Jammu and Kashmir High Court ruled against any effort to abrogate or sidestep Article 370 and upheld it and said, no, you can't touch it. It is sacred to the Constitution of India. And these were the non-Muslim judges. So one could begin to understand, as a lawyer, when you start tracking the legal developments, you become kind of a Jyotishi, a legal Jyotishi, to figure out what is likely to happen. What is this direction of lawfare move which is happening? So I remember, if you remember, in that seminar, I told you, I am very uncomfortable that on 27 February was the date when India carried out that attack or intervention by its aircraft inside Pakistan, and the cause list was cancelled in the Supreme Court of India, a very little noticed event which not many people in Pakistan took note of. I felt uncomfortable. I am not an intelligence person. I cannot make a deduction as to why this was happening, but this was a very strange development. And then that case was parked. It was expected to come up in a month or so, because normally the tradition of the Supreme Court of India is they relist matters. They chose not to. And I was hoping that if it goes to a bench of judges, and any of them was part of those judges who had conducted a press conference against their own Chief Justice, because those judges were not agreeing with the policies of the BJP government, because the Indian Supreme Court is right now clearly divided. There is the old school, which believes it's a secular constitution. They have given judgments after judgments relating to the mistreatment of Muslims and Christians in India by the Supreme Court. So that school of thought is also prevailing. So our sense was, if this case gets fixed up before a bench dominated by those judges, they will uphold Article 370 the way it was. And then still today it hasn't been listed. Only recently it was listed and a special bench was constituted, and that bench is now deferred the matter after issuing notices. So we are trying to understand, after analyzing the names of those judges who are on the bench of the constitutional bench, so to say, as to which way will they swing. Will they go down the route of their own precedent? Earlier precedent compelled them to uphold Article 370, and they had clearly said it in so many words. In one of the judgments, the phrase was, the Jammu and Kashmir state retains portion of sovereignty. Very, very significant phrase to use. It retains limited sovereignty, which basically means it had an element of independence. It had an element that it is not integrated in the territories of India. The title of Jammu and Kashmir territory has not been transferred to the territory to the Union of India. So that was a very material observation and finding by the courts. That is something which could be of enormous utility to you, sir, as a member, as the chair of the committee, as the AJK president, and to the government of Pakistan, whereby they can say, here is what is being attempted to exclude this limited sovereignty, because this is perhaps one of the very few states in India which has the right to hoist its own flag alongside the flag of Union of India. There is a specific act, Flag Act of 1920 or something, and that was also challenged by some of the BJP-sponsored litigation, because now lawfare, as you know, is something which is used internally and externally. You sponsor litigation to achieve strategic objectives. There are pressure groups in Dubai, in Europe and elsewhere who fund you to sponsor, launch certain litigation which advances their strategic objects, including if someone is performing extremely well as chairman of a statutory body, a petition will be filed that he should be removed. I remember representing one such client, I wouldn't like to name him, somebody who was doing remarkably well in terms of national interests and projects and rolling out so many things. And a petition was maintained, and we found out petition was sponsored, because if this man gets out of the way, the entire project development in that sector comes to a standstill. So I requested the judge, I showed him the work of the gentleman. I said, on the ground of very, very petty irregularity, in the process of appointment, don't deprive the state from the quality of the person that we have. So now litigation is sponsored globally and locally as well to achieve strategic objectives. And the Honorable Chairman, Joint Chief, who was here, he in one of the seminars talked about the significance of lawfare. And he had said that we need to build up capacity to understand, to diagnose where things are going. So Article 370 litigation to me is a very, very unique development that needs to be followed very carefully. Now coming to our larger position as to what we need to do on this issue before the world. As I said, Kashmir case is one of the best cases any lawyer can dream of. With 1/10 of this case, we can turn things around in the courtroom. This is a case which is continuously, which is giving you so much of material and evidence, and one of the biggest evidence of the disputed territory, of course, as you all know, are the UN resolutions. UN resolutions passed between 1947 to 1957. And as the President AJK mentioned, this was a time when Pakistan was very little resources were available, but one big resource that Qaid-e-Azam had handpicked was an international lawyer called Sir Zafrullah Khan, and handpicked him and put him in Security Council, and he carried out those debates. And if you look at those debates, you will see Charter had newly come up, so innovative approach towards the interpretation of the Charter that we were able to get over about 15 to 17 resolutions during that time frame. Those resolutions, I submit, are binding in nature. Some people view them as Chapter 6 resolution, and some people were telling me कि सर ये तो देखे ना, ये तो Chapter 6 की resolution है, तो recommendatory है. तो मैं वो अर्ज करना चाहता हूँ कि मैं और मेरी टीम right now इस वक्त इस particular proposition पे काम कर रहे हैं. And the conclusions we have derived so far is that they are binding in nature so far. So I request that we are still working on it, give us a week more on this, because my team is examining each and every resolution passed in 60s by the Security Council. So अगर 1948 में 64 resolutions हैं, तो हर एक का text देखने के बाद we are coming to a conclusion कि क्या इसमें मेंशन था चैप्टर 6 या चैप्टर 7। अगर नहीं था तो फिर कंटेंट और सब्सटेंस डिक्टेट करेगा। चैप्टर 6 और चैप्टर 7 का मतन इन द प्रीएम्बल ऑफ द रेजोल्यूशन मेंशन होना ऐसा ज़रूरी नहीं है। दैट वाज द प्रैक्टिस ऑफ यूएन सिक्योरिटी काउंसिल इन 50s and 40s। The practice was you don't mention 6 or 7. You simply look at the substance, and the substance dictates whether it is implementing or not. And that substance, अगर आप उस क्राइटेरिया को रखें, ये तो अब आया है ना, पिछले 15-20 साल से जब से 1373 आई है सिक्योरिटी काउंसिल की रेजोल्यूशन और टेररिज्म, या 1267 आई है, या 1540 आई है, उस वक्त सिक्योरिटी काउंसिल ने प्रीएम्बल में चैप्टर 7 या रेलेवेंट चैप्टर को मेंशन करने की प्रैक्टिस की दाग बेल डाली है। लेकिन आप आज के प्रिज्म से पुरानी प्रैक्टिस को अगर जज करेंगे तो यू विल कम टू एन एरोनियस फाइंडिंग। सो व्हेन आई हर्ड समवन सेइंग इन सर्टेन मीटिंग्स दैट ये चैप्टर 6 की रेजोल्यूशन है तो ये तो इम्प्लीमेंट नहीं होंगी, तो आई नीड टू करेक्ट दैट परसेप्शन कि प्लीज फोकस ऑन द सब्सटेंस एंड द कंटेंट। एंड मोर ओवर लुक एट इट फ्रॉम अनदर पॉइंट ऑफ व्यू, दे हैव बीन एक्टेड अपॉन पार्टली। यूएनसीआईपी बना, एक इदारा बन रहा है, एक कॉन्क्रीट मेजर सिक्योरिटी काउंसिल ले रहा है, आप कह रहे हैं वो चैप्टर 6 का है, वो महज रिकमेंडेटरी है। यू शुडंट बी सेइंग इट, इट इज अ बाइंडिंग फ्रेमवर्क। इसी तरह वो पार्टली एक्ट अपॉन हो रहा है, जो सीज फायर लाइन है उसके साथ लिंक्ड है। कराची एग्रीमेंट इज लिंक्ड विद सिक्योरिटी काउंसिल रेजोल्यूशन, सो द रेजोल्यूशन का जो सब्सटेंस है वो पार्शली एक्ट अपॉन हुआ वो। टू मी दैट इज अ फ्रेमवर्क ऑफ चैप्टर 7। और इस पर जो हम कुछ लीगल रेफरेंसेस आइडेंटिफाई कर रही है मेरी टीम, वी शुड बी इन अ पोजीशन टू रेज मे बी अ लीगल पेपर ऑन दिस एंड वील पास इट ऑन टू यू एज सून एज दैट इज अवेलेबल टू अस। But this is a fundamental issue that we need to put across to international community with a lot of confidence that this is a binding resolution of UN Security Council. It has to be honored. And we should also posture like that कि देखें ये obligation Security Council के charter की unfinished obligation है, recommendatory नहीं है, binding है, deserves to be implemented because it's been partially implemented. So that should be the position that the state of Pakistan should take formally based on the work that has been done on this. दूसरी important बात यह है कि bilaterally, yes, हम bilaterally बात करने को तैयार हैं, लेकिन bilateral obligation का जो framework है वो इन alternative है। वो उस वक्त है जब सियासी गुफ्तगू आगे बढ़े। अगर वो आगे नहीं बढ़ती तो UN Security Council is the only rock that we need to hang our coat on, and that is how we should proceed. अब हमें मज़ीद क्या करना चाहिए? मज़ीद हमें ये करना चाहिए इन माई व्यू, जो हम करने की कोशिश कर रहे हैं कि एक लीगल कम्युनिटी होती है, ग्लोबल लीगल कम्युनिटी, लीगल एडवाइज़र्स की, लॉयर्स की, जो हर मिनिस्ट्री के साथ अटैच्ड होती है, हर पीएम ऑफिस के साथ, हर प्रेसिडेंट ऑफिस के साथ, हर ईयू का जो सेक्रेटेरिएट है उसका एक लीगल विंग होता है। वो लीगल विंग असेसमेंट करता है एज टू ये 5 अगस्त का जो वकूआ है, इस 5 अगस्त के वकूए की असेसमेंट, इसीलिए लोग शुरू में खामोश थे, लीगल विंग कर रहा था। वो लीगल विंग जो ईयू का है, वो लीगल विंग जो स्टेट डिपार्टमेंट का है, वो लीगल विंग जो एफसीओ से वाबस्ता है, वो असेस कर रहे थे फ़खर इमाम साहब कि ये 5 अगस्त का जो ड्राफ्ट आया है रीऑर्गेनाइजेशन बिल 50 सफ़ों को कहता क्या है। और जब उनको समझ आई कई दिन के असेसमेंट के बाद, तो हम ये समझ रहे थे कि they are struggling before they take a political position, they want to back it up with some legal clarity, and that legal clarity will be given by the legal division. So during Eid, my team worked on a legal memorandum, और इसकी हमने कॉपी शायद आपको भिजवाई थी। This is the one that we फिर आपके पास ये हमने अपलोड किया ईद के नेक्स्ट डे। I was told that within 2 hours over 1,000 copies were downloaded, mostly in America and Europe and India. More than 1,000 copies. So then people began, because we could immediately sense कि जिस तरह हम कंपनीज को रिप्रेजेंट करते हैं, वी रिप्रेजेंट्स, तो हमसे स्टेट या कंपनी सबसे पहले पूछती लीगल पोजीशन क्या है, बिलाल साहब इस पर ज़रा बताएं ना, या किसी भी वकील को अप्रोच करती हैं। तो अगर वो लीगल पोजीशन की वजाहत आप नहीं कर पाएंगे तो आप पॉलिटिकल पोजीशन उस पर खड़ी नहीं हो सकेगी। तो इसलिए we thought if we contribute this will help define the proposition based on which the political position can come up. Now I think, sir, that before the Prime Minister addresses United Nations General Assembly, there should be a legal note circulated which could be prepared by the Law Ministry or the Attorney General Office, a comprehensive legal note on the issue and the dispute of Kashmir. And it should be circulated before the speech of the Prime Minister, so that the relevant delegations in the UN General Assembly are synthesized about the strength, legal strength of the case of Pakistan, and when they listen to the Prime Minister from a political standpoint of view, they are able to respond more or less promptly that yes, Pakistan has a high moral ground, it has a legal strength to the political posture that the state of Pakistan is taking. Likewise, I would also recommend that Pakistan should also reach out to other venues of legal community, which is playing a critical role. Right now, one of my representatives is in Hague. In Hague, international law societies were holding a two-day conference in Den Haag. So we had International Law Society from US, we had International Law Society from China, Russia, and all other countries, including Asian. And there again, we are having communication with them the way, whatever that's worth it, to explain to them that as legal community, this is what has happened to the Kashmiris, and this is how the 4th Geneva Convention affords protection to them. And the 4th Geneva Convention is relating to occupation and annexation. And that will strengthen your argument that you said politically that we don't care about 370 because it is a disputed issue. That's exactly, sir, what 4th Geneva Convention says. It says, irrespective of any tempering and rewiring of the tapestry of the Constitution under the domestic law, the overarching declaration in case of occupation is, it is to be disregarded. It will not be heard. It will not be accepted at all. Europe ka, EU Parliament ka, the legal division head, they've issued a policy position on this, that in case of annexation, we will not accept it. And I had sent that to the Foreign Minister and the Law Minister with my covering note, that when you are having an interaction with the European countries who are EU parliamentary members, you may be mindful of this to remind them that this is your own formulation in which you have noted that in case of any occupation, occupation will not be accepted at all. I would also suggest that the AJK government, sir, also has the option to enact a domestic law within AJK to consider setting up a commission of fact-finding to examine the fact-finding situations inside Indian occupied Kashmir. You are perfectly mandated, the parliament in AJK, to create that and to make and to document that. We need just a legal instrument which will give sanctity to the work of collection of the data from the Indian occupied Kashmir. And when you have that legal sanctity behind the collection of the data, it is not a report, it is not an individual's work, it is a legislatively sanctioned activity which will have much greater ability to be well received before the international community. Likewise, the right of self-determination is also the undercurrent of this entire proposition. We do talk about it in a generic sense, we talk about it in a rhetorical sense, in an emotional sense, but the right of self-determination has so many dimensions to it, it needs to be further studied and gone into. For example, those who have that right, and there are only two communities who are assumed to have that right without any condition. One is Kashmiris, the other Palestinians. The Sikh community is struggling to get that around that right. They are close to it, but they still need to do some legal homework more on it so that they are able to come to this consensus at a global community. Now, what does self-determination translates into for the purposes of those who are under occupation? So you have twin legal features to this. This first legal feature is there is a community which is under unlawful occupation. Second legal feature is its self-determination argument is globally well recognized. So what rights do they have under the right of self-determination? First right that they have under right of self-determination is the right to resist the occupation. And how do they resist is a question mark. From this point onwards, what should be the nature of activity? what should be the nature of pushback, what should be the nature of resisting actions that those who are occupied are entitled to take under international law, is something that we are looking at. Generally, the overarching broad text is 2625 1971 UNGA resolution, which has a status of a customary law. It is not merely a resolution of United Nations General Assembly, it's a customary law standing. So if we have that, and we are working on its details to assess what kind of legal writings and legal commentators have commented on its various phrases. For example, the phrase where it says they have the right to receive assistance. What does it really mean? Will be determined by the case law and by the opinions of international lawyers who have been writing threadbare on it. And as I said, my team is working on that to come to a very concrete conclusion, and I am holding back just to ensure the sanctity of the work, so that once that is done, we will pass it on to you as well to assess that. So, ladies and gentlemen, these are some of the points that I wanted to put across to you in this new context and what needs to be done in a lawfare domain. I think there is a lot of margin, and that margin needs to be exploited, that margin needs to be used, and I hope that this work that Pakistan is doing and the support that the government of Pakistan is extending to Kashmiris will bring them freedom, and that freedom will inshallah bring us that relevant dignity that we deserve vis-a-vis our Kashmiri brethren. I thank you all for the time.